Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer and partner at Rudner Law, Brittany Taylor.
Hi, everyone, and welcome to Fire Away. We're going to be doing something a bit different today. I'm joined by other members of the Rudner Law team, Nadia Zaman, our senior associate, and David Gilles, our associate. We are going to do a legal update. There have been a lot of legal updates and developments in the past several months, and we thought it would be helpful to use the show today to review and highlight some of these for our audience. This is going to include a review of new court decisions on everybody's absolute favorite topic, termination clauses, and perhaps shockingly in 2025, multiple decisions relating to vaccination policies and when a failure by an employee to comply with these policies and be vaccinated is going to constitute just cause for dismissal. There's also been a number of legislative updates and changes which are coming into effect, some in the very, very near future, which we are going to review with you as well. Exciting news that is very, very recent for the purposes of this show, which is great, is that the Ontario government has just introduced a new Working for Workers Act. We are on number 7 of our beloved Working for Workers Acts, and we are going to briefly review these new provisions, which have not yet been passed, but we're going to review kind of what's been put out there so that you guys are kept up to date on that as well. So, Nadia, David, thank you so much for joining me today. I really appreciate you guys taking the time to be here and sharing your knowledge with everybody. So let's jump right in and start with a review of recent decisions on termination clauses. So, David, I'm going to turn it over to you.
Thanks, Brittany. Happy to be here. So, as you said, termination clauses always a hot topic, almost as hot as the Working for Workers Act count. So before I dive right into the recent decisions, I just want to touch on a bit of context. So, basically in Ontario, there are two different standards. We have just cause, and then we have willful misconduct, which is established by the Employment Standards Act. So it's settled law in Ontario that in order for an employee to not be entitled to anything at all, they have to meet the willful misconduct standard, which is a much higher standard than just cause. So there are some circumstances where an employee can be guilty of just cause, but it won't meet the willful misconduct standard, so they would be entitled to notice. Because of that, termination clauses that purport to allow employers to terminate employees without any notice for just cause are not enforceable. And even if your without cause clause is perfectly fine, any just cause equals no notice language will make that unenforceable. So that's the settled law in Ontario. Then last year we got one of the hit cases of the year, Dufo, which invalidated a termination clause on these established grounds. But then the court also considered a novel argument stating that language allowing the employer to end the employment relationship at their sole discretion or at any time was a breach of the Employment Standards Act. The court found that this was a breach because there are technically some situations where you can't terminate employment, such as during a protected leave or for reprisal. So this Dufo decision was very controversial when it came out. It was appealed. The Court of Appeal declined to address these novel grounds. So it was kind of up in the air whether or not this had to be followed. And that brings us to our first interesting decision, this legal update in the decision Baker v. Van Dolder's Home Team, Inc. In this decision, the employee challenged the termination clause because it contained language allowing the employer to terminate the relationship at any time. The court applied Dufo and found that this termination clause was unenforceable because it breached the Employment Standards Act. So this Baker decision confirms that Dufo has to be followed and that this kind of language at any time and sole discretion is offside, and it will render a termination clause unenforceable. So while in our practice we were already avoiding using this kind of DUFO language and other kind of extraneous, unnecessary language, now this decision, it doesn't make that just good advice, but it's just something that you have to do in order to make sure your termination clause is enforceable. So that was a big decision that confirms that you do have to follow DUFO. But it's not all bad news. It's not midnights for termination clauses, as some might think. So in the recent decision, Birch v. Data Stealth Inc., the employee challenged a termination clause that provided that, and I'm paraphrasing, the employment relationship can be terminated with or without cause, upon which the employee would receive only their entitlements pursuant to the ESA, and that these entitlements would satisfy their common law entitlements. The clause also clearly stated that there are some situations provided for by the Employment Standards Act where the employee might not be entitled to any notice. So that's referencing the willful misconduct standard without explicitly saying that it's willful misconduct. So the employee took issue with that and argued that the clause was unenforceable because this ambiguity allowed it to be interpreted in a way that breached the ESA. The court rejected that argument and found that the clause clearly provided for the entitlements the employee would receive, and that it was clear that upon dismissal for or without cause, they would get all their statutory entitlements, and that the clause clearly raised their attention to situations which the employer correctly identified are established by the Act where there might not be an entitlement to notice. So the clause was upheld, and recently the Court of Appeal reviewed the decision and also upheld the clause. So this is good news for employers and for termination clauses because it wasn't a perfectly drafted clause. It did have like a few issues. For example, it had language such as if any, which we think is a bit iffy and can contribute to some ambiguity. And it didn't really specify the willful misconduct standard, but it did raise the employee's attention that there are actually correctly some circumstances created by the statute where there wouldn't be notice. So um, this clause was upheld, and that's something we love to see because if you've been following our blog and employment law updates, it really does feel like there isn't any enforceable termination clause out there, but that's not true. There are some that are enforceable.
That's great. Thanks,
And
David.
then
And definitely a relief for employers, right, to have a decision come out
absolutely
that not just confirms that a clause is enforceable, but gives us the clause so we can see exactly the language that was approved by the court, and use that as a basis going forward when drafting termination clauses. So that's always really helpful. So great news for employers.
great news indeed.
Did you want to talk about anything else, or is that a
Yes,
wrap for your
yes,
termination clauses?
I did. No, there's a little update
I
as
should have
well.
known there's
So,
always more on termination clauses. I should have
but
known
wait,
better.
there is more. There is more. So, there is an interesting move the employer made in this case, which was to bring a motion to strike the pleadings, which allowed the case to be heard within 4 months rather than, the much longer usual timeline. So that's something to keep in mind. And then finally, there is another decision that came out recently, De Castro v. Arista Homes. This is an interesting one because it kind of summarizes or highlights what we've discussed, which is, there are two standards in Ontario, and if you breach the statutory standard, that's problematic. In this case, the clause tried to define just cause, or it tried to define the statutory standard to be much broader than what the statutory standard actually is. So the clause was struck, and recently on appeal, the Court of Appeal confirmed that it was an unenforceable clause. So this is an interesting decision because it does highlight that the tension that exists in Ontario with these two different standards.
Great. Okay. Very interesting. Well, thanks very much, David. I always appreciate when our termination clause update includes both good news and bad news. So, and depending on which side of the aisle you're on, of course. But it's nice to see both a case where a termination clause is struck out and a case where a termination clause is upheld. It's nice to see a little bit of balance there. So, thanks very much for sharing that information with us. And now we're going to turn it over to Nadia to talk about vaccination cases, which is, I'm still a little floored that we're talking about vaccination cases in 2025. But the reality is these are still making their way through the court system. So, Nadia, take it away.
Thank you, Brittany. And I do feel like we are kind of traveling back in time because we don't deal with vaccination issues as much, obviously, now as we used to previously. During the pandemic, a lot of our employers, as well as employee clients, were reaching out to us with questions regarding rights and obligations, whether they have to comply with the vaccination policy from employees' end. And then from employer side, what can they include in a vaccination policy? What can they enforce? What can the consequences be for failure to comply? So I'll be touching on two cases. One is Gilles and WestJet, and the other is Paul and Sentient Colors. So in the first case, Gilles and WestJet, this case involved an accountant who refused to comply with WestJet's COVID-19 vaccination policy, claiming a religious exemption. And she included a letter from her pastor confirming her deeply held religious objection to medical interventions. WestJet denied her request, and they essentially said she was seeking accommodation for secular reasons, not purely religious ones, because she had raised some safety concerns. The Alberta court found that she was wrongfully dismissed and awarded her 11th month notice period. So in this situation, the company had let the employee go for cause. And what the court found is that just cause was a disproportionate response for the violation of the policy. And the court found that the company had failed to properly consider her religious accommodation request. The court essentially criticized WestJet for assuming that the employee's additional safety concerns invalidated her religious objection, and that the employee could hold both religious and non-religious objections to vaccination, and having both didn't mean her request was solely based on non-religious grounds. And in addition, the court pointed out that WestJet didn't request any further information to address their doubts about the employee's religious exemption, even though the accommodation policy expressly stated that employees may be required to provide additional evidence. So WestJet's policy almost worked against the company because they were not applying it or implementing it in a consistent manner. And in making the determination that dismissal for cause was not a proportionate response, the court emphasized that the employee's refusal to comply with the policy didn't negatively impact her performance or put other safety at risk because she was working remotely. Now, interestingly, in the other case I was talking about, so Paul and Sentient Colors, the employee also refused to get vaccinated and was dismissed for cause. However, in this situation, there was no religious or other exemption that the employee had claimed. And although there was a policy which was violated in this case, and the policy clearly stated that refusal to follow it would result in dismissal for cause, the court still ruled that termination for cause was a disproportionate response. And it's also important to note that the court found the employer's mandatory vaccination policy to be reasonable. So even though there were no human rights exemptions claimed, and even though the vaccination policy itself was found to be reasonable, the court essentially held that termination for cause was a disproportionate response. And in particular, there has to be a sufficient connection between the employee's job responsibilities and the requirement to be vaccinated so as to justify the ultimate penalty of ending the employment relationship. And this goes to show essentially that just cause for dismissal is the capital punishment in employment law, which has been solidified in case after case. But in this situation, because the policy explicitly noted that the employer could essentially dismiss for cause, and there were no exemptions claimed, even in that situation, the court found that it was disproportionate. So the standard is extremely high, and employers should certainly exercise caution when deciding to proceed with terminations in general, but especially for cause. And again, in this situation as well, the court considered the fact that the employee primarily worked from home. During the pandemic, her performance had exceeded the job requirements. And also, she had complied with all other safety requirements like masking. So, from a performance perspective, getting vaccinated or not getting vaccinated was not going to have an impact, which is why it seemed to be a disproportionate response. So you might be wondering, what should the employer have done instead if they didn't proceed with dismissal for cause? So first and foremost, definitely seek legal advice from an employment lawyer with expertise in this area before proceeding with any disciplinary action or termination. But in this particular case, the court stated a more proportionate response may have been to review and revise her customer portfolio, temporarily suspend her from customer-facing sales, or even possibly put her on a leave of absence. In this case, she was awarded 12 months notice. So you can see from both cases, 11 months, 12 months notice, the damages were substantial, and it definitely cost the employer to proceed in this manner without, potentially consider the consequences of doing so. And the significance of these cases is that as we move further away from the COVID era, it seems that the courts are getting more lenient in terms of their response to such cases, and it should be approached extremely carefully if employers are still implementing COVID policies. They should be reasonable, they should be implemented in a consistent manner, and any type of disciplinary action up to and including termination for cause should be proportionately applied to the conduct in question.
That's great. Thanks, Nadia. That was a really thorough and helpful summary of these two very interesting cases. And I think to your point, maybe a lot of people would be wondering, well, how does this help me now? COVID is so far in the past that whatever I did is done. But I think it is really helpful and instructive, to your point, just from evaluating the just cause perspective, right? Is understanding how high the standard is and understanding how important it is to take into account the full context of the situation. In particular, in these cases, the fact that these employees were working remotely, right? So the health and safety concern was much lower than it would have been for somebody who was working in person. So I think that's really helpful to note. And as well, I think always the importance of, when you're receiving a request for any kind of accommodation, that you're treating it seriously, that you're giving it time and due consideration, and that you're not automatically rejecting it based on perhaps preconceived biases or assumptions. So I think these cases do still have a lot to teach us, even though it feels like to your point, we are very far away from that point in time when we were drafting vaccination policies left, right, and center. I think still very instructive. So thank you very much for sharing that information with us. And now we're going to turn to legislative developments, because there's quite a lot of them to cover. As you can guess from the number of Working for Workers Acts that we've had, these updates have been coming out kind of fast and furious for the last couple of years. And some requirements from older Working for Workers Act are just starting to come into effect now, or coming into effect in the near future. So we want to make sure that we're highlighting these for you. So we're going to start with the one that's coming into effect the soonest. And by the soonest, soonest, we mean this month on June 19th, our new long-term illness leave under the Employment Standards Act. So Nadia, again, is going to lead us through an examination of this new leave.
Thank you, Brittany. So yes, we have a new long-term illness leave under the employment standards legislation coming into effect June 19th. And this is a new 27-week job protected leave, the long-term illness leave for workers with serious illnesses. This would be one of the longest provincial leaves in Canada to ensure that workers with a serious medical condition have the time to receive treatment and recover before returning to work and without risking their job security, because this would be a job protected leave under the Employment Standards Act. So while employers already have a duty to accommodate employees up to the point of undue hardship, based on their legitimate needs protected by the Human Rights Code, such as disability, this long-term illness leave being codified in the legislation further signals to employers the importance the government is essentially placing on the safety and well-being of workers. And as these changes are coming into effect, employers should make sure that they're staying up to date and complying with the law. A good starting point for that would be to review any existing workplace policies, including those relating to leaves, and then making sure that they're revised as appropriate in the event they are not complying with the new amendments. There's also a new leave that was proposed in the Working for Workers 6 Act, which is not yet in force and no date has been set yet. And this is for employees who become parents through adoption or surrogacy. They are going to be entitled, when the new provision is in force, they're going to be entitled to a new unpaid 16-week job protected parental leave in order to ensure that they have adequate time to meet the demands of the adoption or surrogacy process. And in order to be eligible for this leave, the employee must have been employed for at least 13 weeks. And this new leave aligns with changes on the federal level to create EI benefits for adoption.
That's great. Thanks, Nadia. So always positive changes to see new protections coming into effect for employees. So that's great. Okay, I'm going to talk about our next two updates, which are coming into effect soon, July 1st, 2025. So the first is new information that's required to be provided to employees under the Employment Standards Act. So this requirement comes out of Bill 79, the Working for Workers Act back in 2023, which amended the Employment Standards Act by allowing for the development of regulations which would require, and this was quite vague at the time, just require information to be provided to new employees or prospective employees in writing and when that information has to be provided. So we knew that this requirement could come into effect at some point in the future. So a regulation was ultimately enacted, which does now require that an employer provide an employee with certain information before their first day of work, or where that's really just not possible, as soon as reasonably possible thereafter. So the information to be provided are things like the legal name of the employer, as well as any operating or business names, if that's different from the legal name, contact information for the employer, including their address, telephone number, and one or more contact names, a general description of where it is anticipated that the employee is going to work. So their work location, especially initially, their starting hourly or other wage rate or commission rate, whichever one applies, and a general description of the employee's initial anticipated hours of work. Now, as I mentioned, these new requirements come into effect on July 1st, so it is important to turn your attention to these. Make sure that your onboarding process, your hiring processes are updated to ensure that this information is being provided. I will say that for a lot of our clients that we work with, and I think for a lot of people who use employment agreements, a lot of this information is already going to be contained in your employment agreements. So this might be a good opportunity to take a look at those, make sure that all of this information is here. I know in some cases, employers might choose not to put a job location on or in the employment agreement. This is a good reason to do that, right? To make sure that it actually is clearly set out so that you're satisfying this requirement. The only other thing to note about this is that this requirement doesn't apply to assignment employees or to employers who have fewer than 25 employees as of the employee's first day of work. So if you're a small employer with under 25 employees, you don't need to be worried about making sure that this requirement is met. Although, as a general practice, having this information set out in an employment agreement is probably still going to be helpful for you in terms of making sure it's clear to all parties what the terms of the relationships are. Okay, so that's number one, information to be provided to new employees. The next update that I want to touch on briefly is actually an update or a revision to the Occupational Health and Safety Act, which is also coming into effect on July 1st. And this is a new requirement for washroom facilities. This one kind of seems like a bit of a no-brainer, but essentially what this new requirement is that a constructor or an employer is going to have this new requirement to ensure that any washroom facilities provided for worker use are maintained in a clean and sanitary condition. So this is now, as of July 1st, going to be enshrined as a requirement under the Occupational Health and Safety Act, which makes sense. This is definitely a safety issue that we want to make sure is covered. And I do just want to note that more requirements relating to this initial requirement are going to be coming into effect in the future. So as of January 1st, 2026, in addition to having this requirement to maintain a level of cleanliness with respect to washrooms, there's also going to be record keeping requirements. So specifically, the employer or constructor is going to have to maintain cleaning records documenting the date and time of the two most recent cleanings for each washroom facility. They have to either be physically posted in the workplace or they have to be readily available in electronic format for employers to access. And these records do have to be maintained for a certain length of time as well. So new requirements coming into effect in the farther future, but as of July 1st, it's really important to make sure that your washroom facilities, if you're not already doing this, are kept in a clean and sanitary condition for your workers. So I'm going to pause there and I'm going to let David talk over and talk about the Digital Platform Workers' Rights Act, which is finally coming into effect, which is very exciting. So I will turn that over to you, David.
So this act applies to workers who use online platforms to accept or decline work. So to translate that into not legalese, think of apps like Uber, DoorDash, or grocery delivery apps, and other kind of gig economy positions that basically operate through apps. So those are digital platforms, and workers who use those apps for work are the workers this act applies to. And the application of this act is limited to Ontario. So why is this act significant? Why do this? Well, if you've followed news about the gig economy and like apps such as Uber, then you'll know that the status of these workers in regards to are they employees or are they contractors has been disputed and up in the air for a while. And while there is a class action against Uber in that regard, that's still winding its way through the legal system. Their status is still up in the air. And that means that these workers basically don't have any rights under the Employment Standards Act or at common law, and they only get the rights that the digital platform employer provides to them, which in many cases means they get minimal to no rights. So this act fills in those gaps and provides these workers with some baseline of a minimal amount of rights and entitlements that they didn't have before. So I'll just cover these from a high level perspective. So again, the act provides kind of a floor of rights and entitlements for these workers, and similar to the Employment Standards Act, these entitlements and rights cannot be contracted out of. So they always apply. And then some of these key rights require, for example, the employer to provide the worker with basic information about the app, how it works, how their compensation is calculated and paid out, and how the performance ratings for workers operate. It also establishes a minimum wage. It establishes the right to established pay periods so the worker knows when they're getting paid and at what frequency. It also creates protections for workers against deductions from their wages and tips, as well as protections against reprisal. And it also establishes a minimal notice requirement. So before the company can remove a worker's access to the app, they have to provide the worker with written notice along with a reason for the removal, at least 2 weeks before access is removed, if the removal of access is for more than 24 hours, unless the reason is for willful misconduct, which is defined similar, or actually pretty much the same as in the Employment Standards Act. So this act basically grants these workers with these minimum rights, and the aim is to fill in those gaps that didn't exist before because there was some, a lot of concerns about exploitation in the gig economy. So this aims to address that.
That's great. And this is coming into effect on July 1st?
On July 1st, so 4 weeks from now, if you can believe your calendar.
Wow. I can't believe the calendar, but I'm going to trust that's correct. That's great. Thanks, David. So any employees who are gig economy workers, any employers who have employees or perhaps thought they had contractors who were gig workers need to be aware of the new requirements coming into effect. So definitely reach out to us or another employment lawyer in order to get advice on this because it is imminent that these requirements are coming into effect. Okay, so I'm going to take the ball back into my court to talk about the new job posting requirements coming into effect under the Employment Standards Act. This is probably one of our most farthest reaching in terms of in the future coming into effect changes that we're going to be talking about. So this is coming into effect on January 1st, 2026. So employers have been given lots of notice about these changes coming into effect because they are I don't want to say extensive, but there's lots of components to the requirements here. It doesn't just deal with job postings as the name might suggest. So these requirements arise from both the Working for Workers Act 4 and 5, as well as regulations passed under these pieces of legislation. I do want to be clear that these requirements only apply to employers that have 25 or more employees on the day that the job posting is posted. And again, this only applies to publicly advertised positions. So this is not going to apply to a general recruitment campaign or a help wanted sign. It's also not going to apply to work that happens outside of Ontario. Okay, so those are kind of the limitations in terms of the broadness of the reach of these requirements. But if you are an employer with 25 or more employees as of January 1st, 2026, and you're going to be issuing publicly advertised job postings, that's when you need to pay attention to these requirements. So what exactly are the requirements that we're looking at? Well, the first is that the employer is going to be required to post an expected compensation range, right? So they have to include information in the job posting about the compensation that the employee can expect to receive. And this range can't exceed $50,000 annually, right? So a compensation range of $0 to $150,000 is not going to be acceptable for purposes of the requirements. It does need to be within that $50,000 range. This expected compensation range requirement is not going to apply where the expected comp, including just at the high end, is more than $200,000. So that's another exception where this requirement wouldn't apply. Going on in terms of other requirements for these job posting changes, another one is going to be no Canadian experience requirement. And this is basically exactly what it sounds like. An employer is going to be prohibited from including any requirement related to Canadian experience in a job posting or any type of associated job application form. We also have a requirement to disclose the use of artificial intelligence. So if an employer is using AI to screen, assess, or select applicants for employment, they're going to have to disclose that in any job posting. Now, AI is defined in the regulation, just to make sure that it's clear about what we're talking about, as a machine-based system that for explicit or implicit objectives infers from the input it receives in order to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So we do have a definition of AI. I'm not sure how clear it is, but it's there, so that we understand what we're talking about. I found that the term AI gets thrown around a lot. So this is what we're talking about when we're talking about the use of AI. Other things that are now going to have to be required in job postings include a statement regarding job vacancy. So an employer is going to have to include a statement in the job posting about whether this is for an existing vacancy or any other information that might be prescribed. So we see this language here again of any other information that we might require in the future. Right now, there's no additional information. So we're just talking about including some type of statement about whether the posting is for an existing vacancy or not. The other requirement, which is going to require some proactive steps on behalf of employers, is advising candidates of hiring decisions. Now, a lot of people probably already do this as a best practice, but this is now going to be a requirement under the Employment Standards Act as of January 1st next year. An employer who interviews an applicant for a publicly advertised job posting has to, within 45 days of the applicant's interview, advise them of whether a hiring decision has been made in respect of the position. It can be provided in person, in writing, or by using technology. So it doesn't need to be a meeting that you're scheduling to have this conversation with the applicant, but you do have to let them know. Again, I think a lot of companies do this as a best practice in terms of letting people know who've made it to the interview stage when a decision has been made, but this is now going to be a requirement. And finally, we've got a requirement for retention of job postings, as well as any communications advising candidates of hiring decisions. So an employer is going to be required to retain copies of every publicly advertised job postings and any associated application forms for 3 years after public access to the posting is removed. They also have to retain a record of the information provided to applicants who have been interviewed for 3 years after that notice is provided to the applicant. So additional record keeping requirements created by these new job posting requirements as well. Now, excitingly, the Working for Workers Act 7, I alluded that at the beginning that this has now been introduced. Again, not yet passed. This is not law at this point in time, but it looks like there are going to be some further changes related to job posting requirements. Specifically, that looks like the new requirement that's considered being introduced is something that requires persons who operate job posting platforms to have some type of mechanism or procedure for users of the platform to report fraudulent publicly advertised job postings to the person operating the job posting platform, and to have some type of written policy with respect to dealing with fraudulent publicly advertised job postings. So it looks like rather than changing any of the existing requirements I just talked about, this is going to be an additional requirement for persons who operate these kinds of job posting platforms. So stay tuned for more information about that as we learn more. And now Nadia is going to talk about some of the other changes that the Working for Workers 7 Act is proposing to introduce.
Thank you, Brittany. So I'll touch on briefly with respect to 2 additional requirements that the Working for Workers Act 7 is proposing. So one is job seeking leave. So if 50 or more employees receive notice of termination, so if there's a mass termination, an employee who receives such a notice is entitled to 3 days of unpaid leave to engage in activities related to obtaining employment. So for example, any sorts of job search activities, interviews, and so on and so forth. And again, this is not in effect. This has just been proposed, but it's something to keep in mind for both employers and employees. There's also a proposal for extending temporary layoffs in certain circumstances. So the layoff may be 35 or more weeks in any period of 52 consecutive weeks. but it can't be 52 or more weeks in any period of 78 consecutive weeks. And both the employer and the employee have to agree to the extended layoff in order for this to be allowed. The director also has to approve of this, the director of employment standards. And there are also requirements for such an agreement to be valid. Once an employee has agreed to an extended layoff, the employee cannot withdraw their agreement. So that's another kind of interesting twist to that proposal. And there are also proposed changes to the Occupational Health and Safety Act and the Workplace Safety Insurance Act, including those relating to penalties. And as always, our firm is going to continue monitoring the situation. So follow our blog to stay up to date. And as always, reach out if you have any questions.
That's great. Thank you so much, Nadia, and great finishing advice. Absolutely follow our blog. We do our best, and we really take pride and joy in trying to keep our readers informed as much as possible about changes, including interesting case law, like we've talked about today, and legislative developments as it continues rolling out. I'm sure we'll see many more working for workers acts in the future. This is not the last. So we'll continue to keep you updated on that through our blog. All of these changes, I think, really highlight the importance, and I think both David and Nadia have said this already, but they really do highlight the importance of regularly reviewing and updating your contracts and policies, staying on top of legal development so that you know when you need to reach out to your legal counsel for advice, and for these updates is also really important. We usually recommend at least once a year you're taking a look at your policies and contracts to make sure that they're still helping you, they're still effective for the workplace, and that they're still valid given that we're continuously seeing legal developments happening both in terms of case law and in terms of legislative changes. So I want to thank Nadia and David so much for joining me on the show today. You guys did a great job of summarizing your topics and sharing your knowledge and information with us. So thank you so much.
Thanks for having us.
Yeah, thanks for having us.
Absolutely, my pleasure. All right, thank you. And thank you to everybody who tuned in to watch the show today. I hope you will like and subscribe. We'll have more excellent content for you coming up with our episode next month. In the meantime, if you have any questions or concerns, please don't hesitate to reach out to us, and we look forward to seeing you soon.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.